All right, we're moving on to discuss a couple important narrower topics about freedom of the press, and the first one is libel. Libel is defined as written falsehoods that lead to defamation of character. In other words, these written falsehoods have to be both false and damaging. They can't simply be false, or if they're true, and they're damaging, that's different. So it's the fact that they are both false and damaging which creates the libel, the written, which is basically written slander. Um, we're not talking about the breaking of a criminal statute here. So these are cases generally brought as a tort or a personal tort, and a tort law, it just involves a wrongful act that is not criminal but causes damage. So it's basically like criminal law in the civil context. There's no criminal penalty, but there has been a personal harm done. So until 1964, the states were allowed to create their own standard for these civil claims, and thus we had different standards in each state for what constitutes a false and damaging statement. After 1964, the court attempted to codify these, and states codified them to make this area of tort law more consistent. Uh, and in cases where a jury or a judge finds that libel has occurred, they can assign damages that are both compensatory, in other words, compensates you for harm, and then punitive to punish the party that has published the falsehood. And the most important case in this area is New York Times versus Sullivan, which is excerpted in our text. So this was a case about a report on racial incidents occurring in the city of Montgomery, Alabama, and in particular a one racial incident involving the police there, who were under the direction of the elected commissioner L.B. Sullivan. So Sullivan sues the New York Times, saying that actually it wasn't an article, it was an advertisement. The advertisement, which publicized this racial incident involving the police, actually contained falsehoods. So Sullivan claims that there were falsehoods in the ad and brings a libel action against the New York Times. Now there were in fact falsehoods in the ad which the New York Times published, and the text notes that some of them were rather minor, like the ad claimed that the students had sung "My Country 'Tis of Thee" when they had actually sung the national anthem and so forth. But at the trial, the judge instructs the jury that the ad is libelous per se, which means it is clear that on its face it contains falsehoods and that it was unprotected speech. And if the jury found that the statements were about Sullivan, even though he was not named, if they tended to damage Sullivan's reputation, then the jury could award damages to Sullivan against the newspaper. So all the jury was really called upon to do was to decide whether the ad, which did not name Sullivan, spoke directly enough to his conduct that it damaged his reputation, and thus the newspaper could be punished. So the question here is, does the rule of liability, which we just talked about, this definition of liability for libel, as applied to an action brought by a public official against critics of his conduct, abridge the freedom of the speech and the press, which is guaranteed in the First and 14th Amendments? So does this rule of liability violate the First and 14th Amendment? The court says yes, it does, in a unanimous opinion. Now, the New York Times had argued that the strict rule of liability, which had applied across the board in the United States up until that time, in and of itself violates the freedom of the press. The newspaper argued, "It is implicit in this court's decisions that speech which is critical of governmental action may not be repressed upon the ground that it diminishes the reputation of those officers whose conduct it deplores." So even if there were falsehoods contained in the ad, the fact that it was critical of government was important enough to protect the speech and also to release the press from liability for publishing the falsehoods. Here's what the court decided. They decided in favor of the New York Times, and they invoked a new rule. They say this new rule prohibits a public official from recovering damages for a defamatory falsehood related to his official conduct unless he proves the statement was made with actual malice, that is, with knowledge that it was false or with reckless disregard for whether it was false or not. Okay, so if there was malice and an attempt to publish a falsehood specifically to defame, then a newspaper could be held liable, and this new rule would apply only to public officials, to reporting on public officials. So that rule is much more lenient toward newspaper reporting, and allows for a great deal more criticism of government than the rule of liability for libel had previously allowed. After New York Times versus Sullivan, the court, in a series of cases, the court expands this rule, and in two cases, Butts and Walker, the court decreases the burden to prove malice. So, in other words, let's go back and look at this. Malice can only be proven if there is knowledge that it was false, knowledge that the information was false, and a reckless disregard for whether it was false or not. These two cases change the burden to proving malice to highly unreasonable conduct. In other words, the newspaper didn't just get it wrong a little bit or fail to get that third source for information or something like that. It was unreasonable in the manner in which it conducted its research, and which led to publication. One particular instance comes to mind, and that was the publication in the Rolling Stone magazine of a case involving rape at the University of, I believe it was the University of North Carolina, and that actually led to the resignation of an official and a lot of criticism of that official. And I think that in reports of how the research was conducted by Rolling Stone magazine into this alleged gang rape that supposedly occurred at a fraternity house, I think we can see some highly unreasonable conduct. I'm not an attorney, but it sure does seem from the accounts of the way Rolling Stone went about researching the claims, uncovering evidence that the claims were untrue, and then going ahead with publication anyway. Certainly seems that there's some unreasonableness there, but that's for a court to sort out. Also, Walker increased the coverage of the Sullivan test to public figures. Now, earlier I was making a big deal of the rule applying to public officials. Well, there's a difference between a public official and a public figure. A public official could be a public figure. A public figure is not necessarily a public official. A public figure would be a celebrity or a person who has a national reputation. I am a private individual. My reputation is largely private. I study the courts, but I'm not like Jeffrey Toobin, who has a national reputation. And so if someone slandered me or libeled me and harmed my reputation, then I would be able to pursue a rule of liability, application of the rule of liability for libel against the offending publication. But if somebody libeled Jeffrey Toobin, he would have a much more difficult time. He would have to prove that their conduct was highly unreasonable. Also, another case, Time Incorporated versus Hill. The court expanded the Sullivan test to include not simply public officials and public figures, but also matters of public interest are included in the Sullivan test, and so you basically get protection for a whole host of newspapers that report blatant untruths on matters of public interest. Okay, so here's the overview then. Public figures must prove libel. Any story that deals with public officials, public figures, or of the public interest are subjected to a highly lenient test for libel. Private citizens, however, are protected where public officials may not be. And the Sullivan standard is still good law today. It still applies to public figures, public officials, and matters of public interest. All right, thank you very much for listening.